Hi guys, it's Kathy. I hope you're doing well. Today we have a mixed bag. The first clip is for one of our viewers, Josh. If you're new to this channel, we also do an OJ live stream and get really excited when there's sanctions. So the first clip we're going to do is we're going to do a segment on sanctions for a lawyer for Josh. And my cat is coming. And then we're going to do some child support. We're going to do some bond revocations. It'll be a good day, guys. But let's start with the sanctions.
Okay, good afternoon. Can everyone hear me?
Yes.
All right, welcome to a hearing in the 5th District Court of Appeal via Zoom. We are here today on an order to show cause issued to Attorney Richard Wilson for why he should not be sanctioned for impugning the integrity of the judges on this panel. I'm Judge Eric Eisnagel. I'm presiding today. I'm joined on the panel by Judges Evander and Judge Nardella. Just a little housekeeping item. The court has been having some technical difficulties with the internet today. So if anything happens with our connection, we'll deal with that as it comes. But just so that everyone knows, there have been some technical glitches today with our internet connection. Mr. Wilson, we received your written response to our order to show cause. And to open the hearing, I'll just give you an opportunity, if you would like, to make any other statements or address anything else other than your written response, which we have received and reviewed.
I'll keep my remarks brief because I think I set out in the written response what my position is. I think there are two reasons why the court should not impose sanctions. First, I did not impugn the integrity of a judge on this panel or the panel. I simply said your decision to affirm the trial court was wrong and did not follow the law. And I believe, going to the second point, that that statement is protected under the First Amendment. I laid out the case law. Florida versus Ray established the standard which trial courts and appellate courts must use in determining whether a statement is privileged under the First Amendment. And in the Ray case, and most recently in 2018 in Florida Bar versus Patterson, they said the test is whether an objectively reasonable factual basis existed for the statements. Now, nobody has said that that paragraph 21 of the marital settlement agreement was not a contract between parents to waive child support. That's what it was.
Counsel, before we get to that, I had one question I wanted to just clear up. In your written response to our order to show cause, you questioned whether or not why we asked you to address the Golson versus Golson case, and you indicate that you didn't cite Golson versus Golson in your motion for rehearing.
In fact, I believe I may have said, I don't have it in front of me, but I may have said it has very little applicability to this case. That was a case that Judge Stacy brought up.
Counsel, didn't you cite in your motion for rehearing, contrary to what your written response said, didn't you cite Golson versus Golson in your en banc certificate of counsel, and specifically representing that our decision conflicted with both oral versus oral and Golson versus Golson? And I'll direct you to page 6 of your motion.
Okay, what you're watching right now is the very beginning of a brutal slap down, disbarment, ending of his career of this lawyer. This extremely elderly lawyer was still practicing law at this point, right? This hearing is the first step. They took this hearing and they found that there was nothing, and this is the first step. So it went up to the Bar Association, then it went to the Supreme Court, of Florida. But what we're watching right now is the first hearing where the bar is saying, the counsel is saying, wait a second, you can't say that about us.
Excuse me. I have page 6.
See at the top there, right under oral versus oral, my copy, you also cite, on my copy of the hearing, you also cite Golson versus Golson. Is that correct?
Not on page 6, Your Honor.
On the top of my page 6, it says oral versus oral, and right under that, Golson versus Golson.
Are we talking about my written response?
No, we're talking about your motion for rehearing.
I'm sorry. I have the written response.
Your written response says that you did not cite Golson versus Golson. But I'm now referring to your motion where indeed it appeared in my copy, you certainly did. In fact, you based your en banc request on Golson versus Golson. Page 6 of the motion for rehearing.
I have it.
So is that just so, I mean, am I missing something, or is your statement in your response that you didn't even cite Golson, is that incorrect?
That may be incorrect. If I might, the trial court cited Golson as a case she referred to. My position in the briefs was that Golson had very little applicability, if any, to this case. I think the critical case is oral, in which the court.
Counsel, let me
Yes.
ask you this. When you say that, I take your comments to mean that you're saying that all you did was say that this panel got it wrong in the motion for rehearing, which every motion for rehearing I've ever seen says that in some way that the panel got it wrong. But how do you explain this statement, for instance, in your motion for rehearing? From the inception of this case in 2009, not a single court, including the panel in this case, has demonstrated any interest in the best interests of the children of these parties.
I'm not exactly sure what you're asking, except that we know that Judge Cemento did nothing but sign an order that was sent to him. There was no inquiry in his court on the best interest of the children. Judge Stacy never mentioned the best interest of the children, except to say that her modified judgment was in the best interest of the children. She never talked about the original proceeding, and this court has not had the opportunity to discuss the best interest of the children and did not do so. And my statement is what I see from what the 3 courts did and my knowledge of the facts of the case and the case law. And no judge has said that paragraph 21 was in the best interest of those children, nor could any judge say that.
When was the original final judgment rendered, the original?
I want to say September 9th. That September 9th or 8th. It was September of 2004.
2004, many years ago, correct?
Yes, sir.
In your reply and in your response to this court's order to show cause, you did not address the argument raised in the answer brief, which is that, hey, there's a difference between a void marital settlement agreement and a void judgment. When you have a final judgment, there is a finality issue and a jurisdictional issue that does not apply to marital settlement agreements. You didn't address that argument in any of your responses. Would you care to address it now? Explain to us why you think that an issue in a marital settlement agreement makes the resulting final judgment that was rendered in 2004 void.
Well, I'm not sure whether I'm being hyper technical. I have never challenged the final judgment. In fact, the overwhelming majority of the provisions in the final judgment are perfectly valid and were adhered to by the parties.
Well, counsel, I'm not asking you about those. I'm asking you about the challenge you attempted to make in this appeal to the 2004 judgment.
Paragraph 21.
Of the judgment, yes.
Correct. That's a void paragraph, void, according to what oral said, because no one disputes.
No. Counsel, didn't oral, first of all, that was in dicta. I've read oral several times. That statement was in dicta, but even if it wasn't, that was stating a marital settlement agreement would be void. It wasn't dealing with a final judgment, was it?
I don't believe it was. And
Okay.
I don't believe
So
I've
did you ever address the argument that was raised in the answer brief, which is that, hey, when you're dealing with a final judgment, it's a totally different ballgame because you have jurisdictional and finality issues involved that you don't have with a simple marital settlement agreement issue?
Well, the marital settlement agreement was part of the final judgment. It was incorporated into the final judgment.
Mm-hmm.
And it is an unlawful provision.
Guys, chat. Can we just really not go back in time? Because when you post things like that, I'm feeling as old as this guy. Can we just 6, 7, sheesh, something to make us younger? Because I feel like I'm 90, like this guy. This guy is 90-some fighting for his job, telling the whole panel they're stupid. I don't know what the hell they're talking about. Oh.
Nobody disputes that. Nobody. Everybody either acknowledges or is silent about the fact that these parties did what the law says they cannot do. They
Counsel,
agreed.
In your motion for rehearing, why did you reference this panel's oath that we all took and then say that you're confident that each member of the panel took an oath with swelling pride and a firm determination to abide by its principles in every single case? Sadly, this case apparently fell through the cracks. What was the purpose of making that statement in your motion for rehearing, counsel?
I'm not exactly sure. I wrote that some time ago, except my position is that you did not follow the law in this case.
Would a reasonable reader take that statement to mean that we erred legally or that we intentionally did not follow the law?
I thought I was pretty clear that you made a legal error.
So you're not taking the position.
Your Honor, let me be specific. I am not challenging in any way the competence, the qualifications, the integrity, any bias, none of it. That's not.
In the motion for rehearing, were you saying that we intentionally or knowingly refused to follow the law? Is that what you were saying?
No, I'm saying you didn't follow the law.
Can you understand that based on the way you said it, that the panel members read it potentially as you were saying that we intentionally did not follow the law?
From this colloquy, yes, I can see that. I can see how the panel could have read that as a challenge as a statement that you intentionally did not follow the law.
But that's not what you were saying?
No.
Okay.
My statement is the PCA affirmed a wrong decision, and when you affirmed that decision, that was contrary to the law, and you did not follow the law.
Do any other members of the panel have any questions or comments?
Yeah, I'd like to make some comments. Mr. Wilson, I know you're an experienced attorney. I want to just turn things around a little. Now, you'd agree that our court rejected your legal arguments, right?
Yes.
All right. Do you see a difference between making a statement, someone made a statement to you that said, Mr. Wilson, looks like your legal arguments were wrong or the court rejected them, or Mr. Wilson, looks like the court rejected your legal arguments, which would seem to demonstrate that you had no interest, that you were never interested in your client, you made the wrong arguments, didn't have any interest in the best interest of the children. You threw this case in the lawyer's trash basket, and you took an oath when you became a member of the bar to zealously defend your clients, but somehow that didn't happen in this case. You think there's a difference between those two statements?
No question.
All right. One deals with a professional disagreement on the law, and one is impugning the integrity of the court. Now, you say you didn't mean to do that, but do you understand how your references to judicial trash basket, your reference to an oath, your reference to no interest in the best interest of the children, do you understand how a reasonable person could conclude that that's exactly what you were doing, was impugning the integrity of the court?
I agree that reasonable persons may differ as to the intent of those statements. Yes, sir,
So
I do.
why is there a reference to the oath? Because the oath, no one takes an oath that they will always make the right legal decision, or they always make the right legal argument, because none of us are capable of going through a career being 100% right, whether as a lawyer or a judge. So we don't take an oath for that. So what's the purpose of you referencing the oath in your motion?
Your Honor, I have read that motion for rehearing. I can't begin to tell you how many times since your order to show cause. And as I go through that entire motion, that statement is the one I wish I had not included.
Okay.
And I understand how, when you read that statement, that came across to you as a challenge to your integrity. You took an oath and you didn't follow it. I can't undo it. I can't suck those words out of the motion for rehearing, but I can tell you that I regret having said that. And had I had an opportunity to think about it and rewrite it, I don't think that statement would have been in there. And for that, I apologize.
Good.
That reference to the oath not only did not add to the argument, but I agree that if they had said that about me, I would have said the same thing. What are they challenging me? They're saying I took an oath and violated. So I understand, and I'm sorry those words are in there.
How about judicial trash basket? Any regrets on that?
Well, I think that's probably hyperbolic more than anything else. My complaint is this. And as I pointed out, I've never charged this client a penny.
Your complaint? Sir, you're about to get disbarred. If they are complaining about you, why are you bringing up your complaint? Why are you telling them what you want? Why are you telling them your problems? You're fighting for your job.
I did this case because those children were cheated out of thousands of dollars, and I have put in hundreds of hours fighting for those 3 children. And I have yet to have one judge sympathetic to the needs of those children to address the contract that those 2 parents entered into. My client hoodwinked at a time when she wasn't represented. She was talked into signing it by her former husband's lawyer, who had no business ever giving her legal advice anyway. But that's my purpose in the case today. That's my purpose from this when it started. And I cannot tell you how frustrated I am that I have not been able to do anything about that money.
Let me make a couple more comments and then let my colleagues finish. As Judge Eisnagel mentioned, we get motions for a hearing, probably about half our cases. So I'd assume about 1,000 a year. And in some way or another say, panel, you got it wrong. That's fine. It's part of what happens in our system. And sometimes, occasionally we grant the rehearing because we reconsider. Now, the order to show cause hearings, we probably average, based on a motion we're hearing, what someone says, a belief they crossed the line, about one a year. So I don't know of any others in 2022. Of course, we're only in August. So, you know, I appreciate you, you saying a couple of these things shouldn't have been in there, because there is a difference between saying you're wrong and implying that you violated your oath, and implicitly that, you know, suggesting intentional disregard. Now, if we want to talk about interest in the best interest of the children, yeah, I handled family division for years and and juvenile dependency for a year and a half. I mean, I get it. And if this was before us on a direct appeal, you know, I can't speak for the other judges, but I think the trial judge messed up by not getting the, you know, the child support guidelines and like he's supposed to. Now, the fact that a final judgment says $1,000 will be paid in child support, there's nothing inherently, you know, red flag saying this is void on its face. And that's why you have the child support guidelines to see if there is a problem. But you're dealing with a totally different situation. I don't think you really addressed in the brief, like Judge Eisnagel brought out. We're not talking about an agreement that may be void. We're talking about a final judgment that wasn't void, that had legal error in it. And I agree it's legal error. And I don't doubt that the children may well have been shortchanged. But the rule is pretty clear on when the judgment needs to be challenged. And at least in my mind. And sometimes applying a rule on the finality of a judgment creates an unfair result. But the other side of it is if you don't have a rule like that, judgments are never final. I mean, you know, to accept your argument, 30 years from now, this case could have been brought against the estate of the husband. You know, it could have been 50 years after the judgment was entered if we accepted your argument. So I'm just mentioning that as far as why there's a legitimate disagreement on the validity of your argument. But to me, that's not really why we're here. Why we're here is you crossed the line with some of your comments about judicial trash basket, the reference to the oath, and things like that. You know, your legal argument, that's fine. You know, you made your argument. We disagreed. That happens all the time. And like I said, we get about 1,000 of these motions for a hearing. And as far as I know, you're the only one we've had come in front of us because of what I believe was crossing the line. And I do appreciate your reference to you wish that hadn't been there. Let me ask you, you put in your response that you're leaving the state. Are you retiring, or what's the deal on that?
This is the only case I have left. And
Okay.
I am moving out of state.
Okay, well, I wish you the best with where
He asked if you were retiring. You skipped that question. You just completely skipped it. Are you retiring? The answer is absolutely yes.
you go. I commend you on your efforts to help the children and the wife in this case. We disagree with your legal argument. And I think deep down inside, I think you probably know that you went over the line in some of your comments on the motion we're hearing. So I'm going to leave it at that.
May I very briefly respond?
Sure.
And I'll reiterate, you're exactly right. I acknowledge that comment should not have been there. But you raise another critical point. And in my initial brief, I cited many cases. I cited several cases which say that a void judgment, agreement, whichever, may be challenged at any time. This agreement was approved by Judge Cemento in 2009. I filed the lawsuit in this case in 2000, or the supplemental petition in 2015. And the cases I cited talked about challenges that were brought way more than that. We're talking 5, 10, 15, 20 years beyond.
The void judgment, void agreement.
I remember, panel, 1905. Remember that case from 1905? I stood before the Supreme Court back then. I was right. 1905, look it up, I was there.
Does not necessarily make it a void judgment. Well, I'll just say I reject your argument that this was a void judgment. So I'll just leave it at that. And I definitely see a difference between a void agreement and a void judgment. And here we were not dealing with a void agreement. We were dealing with a contention that a judgment was void. All right. I don't know if any of the other judges
Here's
have
his
comments.
twin,
But,
T.
that's how I'm wrapping my comments up.
I pray when I'm, but not when I'm in my 90s. I'm not going to make it that long. But when I'm in, later, I'm just like him. I pray that I tell people exactly what's on my mind and that I'm still working and I don't stop working.
Judge Nardella, did you have anything?
I do not.
Oh, I was
Okay,
waiting to
thank
hear
you.
what she was going to say.
Mr. Wilson, I'll just conclude by saying that the answer brief very expressly made this argument, and we don't need to rehash the legal arguments here. That's not really why we're here. But I do think that some of the comments that you made in your motion for a hearing, which you now acknowledge, some of those were over the line, or they were the whole situation was exacerbated by the legal argument that you failed to address anywhere. You didn't. It was made in the answer brief very clearly that you had a jurisdictional problem here because we were dealing with a final judgment. You didn't address that anywhere, and that exacerbated it. It probably would have been beneficial. It probably would have been better for you to acknowledge some of these things in your written response. But I think the panel appreciates your recognitions today that some of the comments, like the trash basket and referencing the oath, should not have been made. With that, I will give you an opportunity to make any final statement that you'd like to make before we conclude the hearing.
Thank you. I am concluding a 46-year career as an attorney and mostly as a trial lawyer. I have never been disciplined by the Florida bar. I have an absolutely clean history. I've had disputes with courts. That's the job. But my only interest in this case from day one, I've never charged a penny, has been in the best interest of those children to try to recover some money that I think, objectively speaking, they were cheated out of. I have not been successful in doing that, and for that I am extremely sad and frustrated and sorry.
Okay, Mr. Wilson, thank you for that. And with that, the court stands adjourned.
Fast forward. Okay, the case goes in front of the bar, and the bar finds him guilty. The case goes in front of the Supreme Court. The referee, he was found guilty on all 5 counts. Impugns the integrity of the judges without an objective, factual basis. Filed frivolous hearings and en banc motions, misrepresented the record, engaged in conduct prejudicial to the administration of justice. The referee found all of his testimony was completely not credible, and he was disbarred. And he did move, but I don't know where he moved to. I don't know if he just, if he's just said or not, but I think in your 90s, working is fine. I'm not saying that in your 90s you can't work. I want to work when I'm in my 90s. But as a lawyer, as a judge, as a doctor, as a nurse, driving a car, I think we don't allow children to do that. But we allow children to, build Legos. But we don't allow them, they're not a judge in a courtroom. And in your 90s, I don't think that you should have a job. I just think that there should be an age limit. Just because, yes, he has a lot of experience and a lot of wisdom. Absolutely. He does. But how well you function when it's critical thinking, and like, he can't let go of the fact that he lost that case. He lost that case because the jury or the judge found that he lost that case. With all of his big experience, he should realize then he needs to move on. But no, he's old, he's wise, he's the smartest in the room. Wow. We are going to go to this is almost slightly rude to go to this next one, but we're going to Judge Dad next. 9 minutes and 57 seconds in is where we're going to start.
Well,
How is my size?
I'm troubled.
Good.
I'm going to tell you my negative comments first. One of the things, I've been sitting here quite a while now, and one of the things that I always think of is how do I say this delicately? It's an impossibility for our society to improve if we don't have parents that care them. Can't do it. Impossible. And I'm not saying every parent, I'm not saying majority of parents, but certainly there's a sufficient amount of parents out there that don't get it. They don't understand. They just don't understand. You can't have parents that don't care about their kids. Because when they don't care about their kids are smarter than we give them credit for, even when they're 2 or 3 and they don't even know that they're thinking. And they know when they're loved and they know when they're not loved. And they know when people care and when people don't care. Now, I'm looking at this from and I told you I'm going to tell you the negatives part first. I'm looking at this and I'm saying, do you have a young child in your car? And that child at the time, now you've got 5 kids and you're looking for a 6th, right? Right?
Yes,
And the child that was in the car was how old?
it was 2.
Okay. And you were pregnant when you were doing this, right? On its face, the child has no chance. On its face. No chance. I feel so poorly or badly about the fact that so many kids come into this world and they have no chance because they have parents that are not doing the right things. And I didn't say it's an easy job. I'm not sure any of us are equipped to do it, but it's certainly not an easy job. But we have to try. And we can't have kids when we're doing cocaine and hallucinogens and amphetamines and sedatives and inhalants, and now we're smoking marijuana and we're drinking. All of that, you don't need a legal scholar to tell you that. You don't need a substance abuse counselor to tell you that. You don't need a psychiatrist or psychologist to tell you that. You just need somebody with common sense to tell you. Just a little, they don't have to be overwhelmingly intelligent. Now, that's the bad news, because I'm just really floored by some of the things I read in. I really am. We just can't do this. We cannot do this. The good news is, I believe that you're sincere about this. But don't go out of here. And I'm telling you, I'm not saying you're going to be one of them. But I just have sensed, and I can almost see it when they leave the podium. There's either one's boy, I got lucky and I'm going to stick with it, or judge didn't send me to jail. I'm okay. Now I can let my guard down. There can't be any letting of your guard down. If I want you to understand that if you don't comply and make it through sobriety court, you will do a year.
I understand that.
I hope you do, because there will be no ifs, ands, or buts about it. There won't even be a consideration.
I understand.
Now, so far, you've at least weaned yourself off the marijuana. But I'm telling you, nobody can argue with me that alcohol and drugs being consumed by a pregnant woman is anything but horrifically bad for the child. And I don't know how to put it to you this way, but other than saying, I mean, kids are bigger than we are, right? I mean, we should be doing everything we can to make them successful, to make them have values, have integrity, work hard, making them understand the world doesn't owe them a living. I'm going to cut you a break, but I do not want you to walk back from this podium, because there's going to be a lot of requirements here. And I want you to understand, you violate, and you're going to get every single day I can give you.
I understand.
Do we understand that?
I do.
Now, the prosecutor's office, they come out with these things, and they wanted me to send you to jail in so many ways. I'm going to read it to you just to remind you what they said. Sentence agreement of 60 to 90 days is determined by the judge with work release if eligible. Maybe waived, jail condition may be waived at the discretion of the court if the defendant completes a specialty court program. Court can impose jail at its discretion for child abuse 4. The OWI 3 charges will be dismissed at sentencing. Really, it was an enhanced from super drunk, second, which makes it a felony, child occupant less than 16 with a prior, which makes it a felony. So there was no OWI 3, but they were enhanced and they were felonies. 2 years probation sentence agreement with sobriety, drug, veterans, or mental health court that the defendant will need to find placement on or before sentencing. No early termination. 33rd District program is acceptable. We think it's more than that. Full restitution, parenting responsibility should be included. Defendant fails out of the sobriety court or specialty court due to poor performance, commits another crime while on probation. The judge finds sufficient cause to terminate the balance of the year. 1 year must be served in jail. No work release or waiver. The above are recommendations only, is what I made them add. The court need not order 1 year in jail if the defendant does not successfully complete program. And I've gone round and round with them about that, because they're not the judge. And they have the right to do what they want to do and enter in sentence agreements, but I don't have to go along with sentence agreements. I thought that was overly harsh, especially for somebody that might struggle and get to the end and violate, and I'm not giving them a year. But I want there to be no misunderstanding. And I know I'm talking a lot because I'm troubled by this one. I want there to be no misunderstanding. You fall down on this, you're doing a year. Your lawyer has done a tremendous job for you. Did I let everybody finish? I'm ready to sentence if I did.
Yes, thank you.
Anything else?
No, yeah.
I'll get the count. I'm going to call it count 3. It should be child abuse. They're not adding a count. They're reducing a count from operating while impaired second, which is a 1 year, as far as I'm concerned, to child abuse. Fourth, 2 years probation. You cannot leave, but first of all, you have to comply with all agreements, guidelines, and requirements as indicated in the sobriety court participant handbook. 2 years probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs, and you're not to go to any place that sells or dispenses or alcohol, and I'm talking as its primary source of business. I'm not going to consider it a violation if you go into 7-Eleven and buy a Diet Coke, but you're not to go to any bars. You're not to go to parties where alcohol or drugs are being consumed or dispensed. You're to submit the chemical testing, PBTs and ETGs on demand of probation. We're going to pay for those tests as long as you go every single time, and as long as you test negative every single time. You test positive, you're going to end up paying for the test and you're going to be incarcerated. To complete the recommending 60 days, I'm going to make it 90 days on the sober link. I know you have a scram. We're going to change the scram to a sober link. It's going to be on our dime now with our grant. You fail the test, you test positive on a test, you're going to not only be subject to sanctions, you're going to be paying for your own testing for a lengthy period of time. You're to attend 12-step meetings 3 times per week and provide written proof of attendance. You're to obtain an AA-NA sponsor. You're to attend all substance abuse treatment at a facility approved by probation. You're to attend the Victims Impact Panel. That is one night put on by Mothers Against Drunk Drivers. You're to attend and complete the Armed Specialty Court Weekend Program. You're to report to sobriety court status review hearings with me every 2 weeks. You're to meet with probation in the off week. You're to obtain and maintain employment with proof provided to the probation department. And this is all on count 1. This is all for the OWI occupant. Less than 16, 200 fines, 200 costs, 75 victims' rights fee, $50 justice assessment. So that is 5 1/4. Your screening fee is $60 for 585. You have probation fees of $480, bringing your total to $1,065. You have sobriety court fees of $360, bringing your total to $1,425. Now, I'm going to order that you serve 11 days jail, credit 1. Actually, I'm going to order 15 days jail, credit 1 for 14. I'm going to allow you graciously to serve 10 of those days on the court work program. There is a $35 a day charge for that. You're going to serve the other 4 days by way of community service. You're going to serve 4 days of community service. I'm going to give you time to complete that, and that won't be, I'll give you all the way until May the 31st. You're going to have your hands full. You're to complete 10 days on the court work program and pay a sum of $35 for each day ordered. I'm going to make a note that that is $350 plus your $1,425. So your total here amounts to $1,775. Now, I'm going to talk about court work program fees in a second. All right. Now, if you violate, your probation could be revoked. You could be incarcerated for a year with credit for 1 day served and any other time you serve on the court work program, community service. Defendant not to be completing court work. You're 5.5 months?
7 months.
7 months, I'm sorry. Not to be completing court work not to be completing or starting court work program until at least 3 months after childborn. Your community service, I think you're going to be able to do one way or the other by May the 31. That's not taxing, and I'm not going to have you start on a court work program now. As to count child abuse, I'm simply going to indicate I'm putting you on the sobriety court for that as well. Sobriety court terms and conditions concurrent. This is on, and I want to make sure it's mentioned there, other sobriety court terms and conditions set forth in count 1. to run concurrent. So I'm basically ordering everything on this case that I just ordered on the other one. However, I am going to add a little bit of fines, but not much. Heather, I don't remember. Can you ask Amy? There's one of these, when it's a state case, we don't charge the victim's rights or justice assessment. I can't remember if I charge the 75 or the 50, but not both. So can you check with her if you don't know the answer, or Lisa, please? I'm going to
Yes.
simply go. So I'm not charging any other fees except to say 100 fines, 100 costs, and then you paid the screening fee, you're going to pay everything else, and I will either charge you 75 for the victim's rights or $50 justice assessment. So your total there is either going to be 275.
I'm checking right now.
Take your time, or 250. Again, if you violate, your probation could be revoked. You could be incarcerated for a period of 365 days with 1 day credit. Now, I just want to double check one other thing. They ran Forrest Hughes is who? Boyfriend?
No, he's a friend of mine. He's just a friend. He just helps me out with rides and getting me.
Well, why did we send the victim's rights? He's not the father of any of the children, is he?
No, we were unsure as well. That's why he didn't have anything to say. He didn't know what to say or what to do. And when he called, he couldn't get a hold of anybody around.
All right.
Okay, Judge,
Yeah,
we charged the 50.
so it's $50, something. So it's the $50 judgment fee, justice assessment fee, for a total of $250. So you owe $250 plus you owe on this case, and I can't do much better than this, $1,775. So you owe $2,025. Now, I'm going to let you pay this case, the child abuse. I'm just going to give you a date of May the 1st. Can you do it by then? That's only $250.
I can do that, Your Honor.
And then I'm going to have you pay, and you can tell me if you can do this, but I need you to stick with it. $50 a week starting May the 8th.
I need you to say that again. I'm sorry.
50 per week beginning May the 8th. Can you do that?
Yes.
Pay 50 per week on count one beginning May the 8th. And if you ever need more time, you need to come talk to me. All amounts due by November 1 of 27. Okay? You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. I'm not taking action on the immobilization since you didn't own the car. There's no evidence that the car owner allowed you to operate while knowing you were intoxicated, and that's what I'm going to do. You'll go meet with probation. We're going to switch out the scram. The judge said switch out the scram for Silverlink, and we're going to have to send a letter to the county because that's where she got it at. Heather, she got the scram tether at the county when the bond was set. Okay.
Okay, Judge.
All right. Thank you very much. Good luck.
Thank you.
Have a good day. Nice day to your counsel.
Thank you, guys. Appreciate it.
Curtis Brett Hamadi, 26R70167. Lieutenant, your name?
Detective Lieutenant Steve Mercury, Rockwood Police.
All right, so this is Judge Hessen's case. She's not here. Raise your right hand. You solemnly swear affirm, under penalties of perjury, that the testimony you'll give in these proceedings will be the whole truth. So you got it.
I do, Your Honor.
Go ahead.
Your Honor, December 12th, 2025, at approximately 7:08 a.m., officers Christopher LaFleur and Stephen Corn, both with the Rockwood Police Department, was dispatched to the Rebel gas station 22855 Huron River Drive within the city of Rockwood for a panic alarm. Upon arrival, the officers met the cashier identified as Philip Morales. Philip advised that one of his regular customers by the name of Curtis Hamady had come in the store a couple days prior, and when he walked in the store, Philip asked him if him, who was with his girlfriend, asked him if he was ready for the upcoming holidays. The girlfriend replied, "Ho, ho, ho." Philip then told Curtis's girlfriend that she can do whatever she wants in her free time. This comment made Curtis upset, but he immediately left the gas station without incident. On 12/12/25, Curtis came in the gas station, bought 2 large cups of coffee, and as he approached the counter, he got in an argument with Philip over the comment he made about the ho, ho, ho. As the argument escalated, Curtis grabbed the 2 cups of coffee and threw them on Philip, causing coffee to go all over him as well as the store. Philip then at that point said he was going to call the police and hit the panic button. Curtis left the store. Officer Korn reviewed the store video, and it did show that Curtis, who Officer Korn had arrested prior months ago, could identify him as our subject, Curtis Hamady. On 12/12/25 at approximately 8:25 a.m., Curtis Hamady called the Chief Krause of the Rockwood Police Department on a recorded phone line and admitted to the incident at the Rebel gas station. Curtis told the chief that he said he pushed coffee cups that did contain hot coffee towards the Rebel employee. I sent a warrant to the Wayne County Prosecutor's Office, and you have a charging document in front of you.
Based on your sworn testimony, I find the crimes of assault and battery and disturb the peace were committed. There's probable cause to believe the crimes were committed by the defendant and authorize the issuance of the complaint warrant, $200 bond. Maybe you can call them and tell them to come in the warrants, if Mr. Hamady, I'm saying, and just tell him the warrant's going to remain in effect unless and until he does. And I'm signing the complaint and we'll put it in the lien. Okay?
He's on probation through the court also, so.
Okay, thanks.
All right.
By the way, I'm changing the date. You sent it over the other day, the 3rd or what have you, and so I'm changing the date on there to the 7th.
Okay, thank you, Your Honor.
Happy New Year, Lieutenant. Have a good day.
Thanks, you do the same.
Forms. All right, I called Mabane here. I have 22F2373228, which is a driveway license not valid. 22F237322B, which is a civil infraction, improper lights. 22R512824B, which is a failure to pay on a limited access. 22R512824A, which has not been adjudicated. That's a no ops. I hope she has a lot of money. She's been playing games with us. Your appearance? Name, ma'am? Your
Melanie
name?
Bay.
All right, so what are we gonna do here? She doesn't want to show up, so she's probably gonna have a high cash bond if nothing else. On the no valid license, does she stand mute and wait for a reading? She's only missed about 4 or 5 times on this. And then somebody will be a wise guy and say, oh, you sent somebody to jail on a drive while like, well, I don't know what else to do short of tackling them and bringing them in here. What if she's got others, limited access, $306. Does she stand mute? This is on the limited access from 2022.
I think we got the big traveling pocket for tomorrow, so you'll do it upstairs.
Boy, you don't have much respect for courts, huh?
No, I actually.
Somewhere between 0 and negative 2,852, it looks like to me. I mean, Judge Heston's been overly kind. Okay, shake your head. Judge Heston's been overly kind with you.
Yes, I
Does she
appreciate
stand mute
that.
and wait for a reading on the other one?
Yes.
A guilty plea on that. She has flat rock in front of Judge Heston, failure to pay. Does she stand mute and wait for a reading on that?
Yes.
Wow. If I had a nickel for every time you missed a court date, I could. What's she doing? What is she doing? Who does she think she is?
I don't live here.
And give a lot of feedback.
Well, good. Hang on. What's wrong with the, you live in Toledo. You don't live in Juneau, Alaska. Give me a break.
I lived in Atlanta.
I would quit while I'm behind right now unless you got a lot of money with you right now. Okay? I don't really want to hear it. I don't want to hear it. Tell it to some other judge in some other city in some other state. Where does she work?
Director
Got a problem.
makes fun of themselves.
She missed April 14th of 22, May 12th of 22. Came in October 12th, or was brought in, I believe. She was given her, at least it was on Zoom, given another date, January 3, 23. She didn't show up then. She was show caused again in June of 23. She didn't show up then. Wow. And that's just one file. That's just one of the files. I don't feel the need to go through the rest of these. All right, Heather, how much does she owe on all of these? On 224B and, I'm sorry, on 824B and 824, 322A and 322B. I'll set those together.
322A has a balance of 411. 322B has a balance of 248. And then 824B has a balance of 306.
All right, I've got these a little bit mixed up here. I got 824B that has a balance of 306, true?
Yes.
All right. I've got 22F, 237, 322A that has a balance of
411 on that one.
411. She only have 3 files, or she have 4? She has 4, doesn't she?
4
What are you talking
altogether.
about? I'm playing it.
Yeah, I don't know what I did with you.
I didn't record this. I'm playing it right from YouTube. It's not a recording. It's feedback from the jail.
Hang on a second. Oh, no, I see. And what does she owe on 322B?
248.
Where has she been? Is there any valid excuse whatsoever?
Yeah, I don't know, but she moved to a, in 2022, so she came back to me.
Forgot about the meters. Okay. I got it.
He does inform that other than he tests, that he has all the criminals. Giving, put a, that on the file with updated assessment.
Okay. I'm sorry, Heather. 824A, she owes how much?
824A, that's the one that she hasn't been sentenced on yet.
Oh, that's right. So we're setting a pretrial on that.
Correct, Judge.
I see. She zoomed in once, so she wants to make it sound like she lives so far away. She zoomed in. She doesn't need to come in here from Atlanta, but all right. I just want to make sure I got these right. She owes 306 and she has a pretrial on a suspend charge. She's missed multiple court dates. The likelihood of her appearing again is not very good. Judging from what I've seen here, it's nearly impossible to rely on. So on 322A, I'm setting, and that'll cover B as well, 600 cash or surety, 600 cash or surety on 824A. 322A and B are covered together. 824A and B are covered together. Pretrial will be tomorrow, January the 8th at 10 o'clock. You'll be in front of Judge Hessen. And that's it. So you're gonna have to post $1,200 to secure your release. If you post that, great. If not, you'll be brought over. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Young lady, I don't know what they're thinking, but you need to stop doing this. You don't have the right to do this. Good luck to you. Thank you.
Whew, Judge Dad, man, we needed someone to slap us down real quick. That's what we needed. Let's go to Judge Hammond. 307. Only found here. This is an exclusive judge. This is California. So, where's McNally? Is he in Michigan? So we went from Florida to Michigan, and we're going to end in California. This judge is, I haven't seen this clip yet, but this judge is so good. He's so chill and funny, and I have a spinny circle real quick, so hold on. Maybe if I go back a piece. There we go.
Because we kicked those other people out of here. Okay, so let's
What?
see. Oh,
He kicked the other people
I
out.
have.
Maybe I need to rewatch that part.
the findings in order after hearing already. I'm not used to that, except out of this department. So there was some discussion about the children being interviewed,
Yes,
but it doesn't look like you got re-referred to mediation.
It was denied.
it is
Oh, the request was denied?
yeah.
Oh, okay. Kind of interesting. Although I don't know what,
Quit your
would
job.
have come of that, but the children are all old enough to be interviewed by the mediator at Family Court Services.
So he's moving or he's getting a new job out of county in Fairfield.
Okay,
It is not confirmed yet.
I'm sorry,
It's not confirmed.
I still didn't.
It is not confirmed. Like,
It's not confirmed?
I get an offer.
Oh, okay,
Yeah, but they will do background check and stuff.
okay. But he made an order for custody and visitation. Mr. Mills, do you have a calculation up?
I do.
Okay, it's 14% timeshare.
Okay.
And you have as much as I do in terms of
We have,
financial information. I have income and expense declaration filed in October from, it looks like,
I haven't submitted
yeah,
mine
it looks like
because
the mother.
there is okay, sorry.
Well, let's see what he has, because I only have
Oh, okay,
financial information from the mother.
okay.
You're a social worker
Yes.
for a home health? It's a private agency? Yeah, okay.
we have a pay stub for the father from June 27th. The year-to-date of $32,984, coming to an average of $54.97.
Okay, you still working there?
I'm still working there.
Okay.
Yeah. The only reason is they are telling us the work is not going to sustain. They are going to lay us off and stuff. I have been applying, and yesterday, contract to hire job, they reached out to me. It's a better pay than what I am getting paid, but it's contract to hire. So if I pass, I will start background check. If I started, I will notify you if I changed.
Notify them, not me.
Okay, sorry.
I don't want to know unless somebody brings a
Okay,
motion to deal with something.
okay. And then, but as to for now, I'm paying extra from what I have since our separation. I was paying about 600, like paying mom's phone, car insurance, my kids' phone, home insurance, which is about 600 on top of what I am paying. So is it obliged that or because I am very much stretched? That's still going on since June 2020, on top of what the court has ordered me to pay for child support.
This goes with something that we called earlier with Joseph Hoffman.
He's ignoring him. I don't know why.
What have you got, Mr. Mills?
I'm sorry, I didn't know we were done. Just a second. Okay, we get another minus number and the
You know what that means, don't you now, Mr. Mills?
the father has the lower net, 4367, mother,
What's the something?
I'm sorry, what?
What was the number you just gave me?
1414 is the guideline number based on father's net of 4367 and mother's net of 7370.
Okay, and can you give me the allocation? Well, print it for me.
Yep, let me do that right now.
Yes, ma'am.
I pay for the kids' health insurance.
Yeah, that should be in the calculation.
I don't think it is.
Well, you haven't seen it yet.
Actually, she.
That's why I'm having him printed, so I can look at it
Yeah.
and I can ask you questions about that, but he does have the income and expense declaration. You say you're paying $2,000 a month for medical insurance?
I was paying 2,000, now it's gonna be 2,024.
Your income and expense that you filed back in October just says 2,000, but that's all you knew at the time.
Yeah, but it just got renewed for
So
health insurance.
who is that with?
I don't,
But it's not through your job.
I'm paying it, I'm paying it out of pocket.
Is that to cover California?
Yes.
I know I have a check from September 30th. It says medical insurance, $928.75.
That's per paycheck.
Yeah. I
And now
understand
it's
that.
changed, this year has.
Well, wait. I have two other paychecks from August and from August, the two paychecks for the work that you performed in August. The pay you got was August 29th and September 15th. There's no health insurance premiums deducted from either of those. So it's, okay, all right.
Started, yeah, September. I think it started September, but that has changed now.
I hear you. I hear you. He did not give you anything for medical insurance, and actually that is I thought you said you did have her income and expense declaration.
Not sure how old it is.
Well, this can go back to September, so.
I have an income and expense from December of 2024.
Yeah, this one was signed October the 10th, filed on October the 13th is what it looks like.
I do not have that one.
And
Let's see, maybe it's in her response.
no, it was not well, let's see, was it filed at the same time? Yes, it was filed at the same time. And you have
There is-
medical, dental, and vision.
Yes, let's see.
So that's 2204.
I've got 2,000, but you want 2204?
Yeah, she gets paid semi-monthly.
Okay, 2204. That comes to 1723.
Okay. He's getting his steps in today. There's a printer in the other room. Sometimes I complain that he's running screaming from my courtroom because he can't stand it anymore. You locked him out. Way to go. We locked the door because you guys should be the last ones coming into the courtroom.
That's fine.
What's that?
Lunchtime?
We're supposed to finish by 11:30 because he's got other things that he needs to do before he goes to lunch. Ah. Don't get excited because there's,
Yeah, with more to come.
yeah. Now, what did you say it's gonna happen in January to your health insurance?
It's gonna be total of 1,000. I think it's 1,012 every paycheck. Twice, I get paid twice a month, so it's gonna be 20.
You know what? It's not that significant a difference. We're just gonna use this one going back to September. And your oldest child is now 16, going on 17. A sophomore in high school?
Yes, no,
She's a
junior.
Junior, okay. Oh, okay. Well, so you're getting there.
She's got her license, she needs a car.
Well, this is gonna make it easier for you to get him a car, but not for him. Okay, so I will add an arrears, oh, there's already an arrears payment. We'll just leave that.
So it's mom to pay 1723 effective.
17. Oh, 23.
Yeah.
Mom to pay?
No. He said there was a minus number, so it's dad to pay. Right, Mr. Mills?
Okay, there's a minus number and you said that whoever has the lower net is the one to pay?
Correct.
And father has a net of 4367 and mother has a net of 52.
7370.
Okay,
That's the higher net.
the lower net pays. Okay, yeah, it's dad. So it's a change of,
But it's a reduction in the support because he's got 14% timeshare before he had
Yeah.
0.
and you said September, it's effective date?
9/1, yep.
Okay.
That's it.
How much?
$1,723 a month,
It increased?
down from 1,788. And the arrears payment stays the same at 37.
But the kids are going to stay every week, every other weekend.
Every other weekend, yeah. That's your timeshare is now 14%.
That including the health insurance? That-
I am,
That's what I made him go do, was to change it to add the health insurance.
I am paying the house insurance for what the kids live with me.
He's providing health insurance. Do you have Kaiser also?
No, I don't have, I have Kaiser through I'm partially permanently disabled from my work.
You're covered by your work.
I mean, I was covered, I don't know now, because I was partially permanently disabled. And the kids were with me.
Are you guys married?
No,
Okay. Yeah, but they're not with you now.
the kids, they always live with her.
Yeah, and you have them every other weekend. She has them on her insurance. That's
Yeah.
why it's so expensive. Okay, that's the order for today.
So
So,
how about, I mean, like, it is, I paid for their phone. I pay for her car insurance. I pay for her phone. I pay for her house insurance on top of what you are.
that's something you gotta work out between you. All I'm dealing with is how much you're gonna pay to support those 3 kids. if there are other things you guys are doing between each other.
Because I was continuously doing it to begin with since I was out of the house because I rented 2-bedroom house, but she refused to send them to me and they were staying. So while I was covering equally sharing, but for the night that they sleep, I was paying about 600 a month. Still, it's going on top of what I'm paying with this. So,
But the things like the phone are outside of my jurisdiction. DCSS doesn't want to deal with your phone bills or what you're paying in the way of extracurricular activities, or if there's any childcare, which I don't think there is in this case any longer.
But they do have activities that I pay.
I pay for
2,500 for the youngest one, and then all the
$2,500 a month?
space.
Well,
No, a year. About 140 a month.
I pay.
What is she? Oh,
So
club soccer?
They suffer.
Yeah, okay.
I pay for that too.
Yeah, again, we're not dealing with any of that. This is just child support. Other expenses, you so far have been working that out. If you're not and you need some help or want a court order, file a separate motion and we'll talk about it, but.
Okay, yes. I mean, it is because I'm stretched. Otherwise, if I have, I would, but I'm very much stretched. That's the reason. And it's taken as an obligation.
Mr. Mills, you'll get a copy of the order in the mail.
Thank you.
Okay, bye. Number 11.
That poor guy. He doesn't have to pay for her car insurance. He doesn't have to pay for her cell phone. But his kid's cell phone, his kid's soccer, kids are expensive. They are way more expensive than $1,000 a month. No matter how you look at it. So, yeah, you got to pay for stuff. I'm sorry if you're stretched. All right, guys. Someone tell Josh we got sanctions for him at the beginning of the clip. I wish they were explosive sanctions like last night, but hey, a sanction is a sanction. It's like pizza. Last night we had, New York style. But this morning it was more like frozen pizza. It's still pizza. It's yummy. Guys, I'm going to start OJ. Thanks for coming out. I appreciate it. I'll see you all again real soon. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, and see